the access links in the chat for anyone that would like to join us. It's really valuable for organisations who find themselves spread quite thinly in terms of accessing files, working remotely from home, particularly around data. There's quite a number of risky unknowns that I wasn't aware of, and a lot of law firms have asked for this. So if you'd like to join us, you'll be very, very welcome. And again, I'll share the link in the chat function. So thank you very, very much for joining us, and to our presenters from 30 Park Place Chambers and Watkins and Gunn for collaborating with Legal News, and on our 5th event since we launched, as I say, last week. So without further ado, I'd like to hand over to our chair, Christian Howells, who's barrister from 30, and he'll introduce you to our speakers. Thank you.
Thank you very much for joining in the webinar this morning. Hopefully we'll get through the presentation in the first hour, and then we'll have half an hour at the end for any questions. Emma, you can type on the keyboard, I think.
Sorry, could you everyone make sure they're muted, and Christian, could you come a little bit closer to the microphone? Is that okay? Thank you.
There we go. Fine. So I'm going to begin the presentation with a talk on local authority care and support in Wales, and the changes that have been brought about by the Coronavirus Act 2020. As of the 1st of April this year, those changes came into force, and they are Section 15 and Schedule 12 of the Coronavirus Act 2020. And for anybody who would like to make a note of the provision that brought the changes into force on that date, it's Regulation 3 of the Coronavirus Act 2020, Commencement Number 1, Wales Regulations 2020. And the changes provide that local authorities in Wales, for the duration of the coming into force of the Act, do not have to comply with certain duties contained in the Social Services and Wellbeing Wales Act 2014 in respect of adults. So we're not here talking about children, we're talking about adults who would otherwise be provided with care by a local authority under the 2014 Act. The changes to the duties are fourfold. Firstly, the duty to carry out a needs assessment in accordance with Section 19 is suspended. Secondly, the duty to determine whether any assessed needs meet the eligibility criteria pursuant to Section 32 is suspended in part, and I'll come to explain what.
Sorry, I'm trying to watch something else at the same time. I do apologize, but.
Thank you. Could I just say that
it's not as good as you, though.
For everybody who's joined, could I just ask for your
Sorry, can everybody who's just joined, please can you put yourselves on mute, or make sure there's no background noise for me if you're on audio. Thank you very much.
Thank you. So, thirdly, the duty to meet eligible needs in Section 35 is suspended in part. And fourthly, the duty to have in place a care and support plan in accordance with Section 54. However, because the duty to determine needs and to meet needs is only suspended in part, what the local authority still have to do under Sections 32 and 35 is to meet the need of adults if it is necessary to meet them in order to protect the person from neglect or abuse or a risk of neglect or abuse. And the test of Section 32 is that the local authority has to be satisfied that the person has needs for care and support to protect them from abuse and neglect. Now, what does abuse and neglect mean under the 2014 Act? Well, Section 197 contains the relevant definitions. Abuse is physical, sexual, psychological, emotional, or financial abuse. Abuse is not further defined, so it just provides a list of the type of abuses that are covered by the Act. and it includes abuse taking place in any setting, whether in a private dwelling, an institution, or any other place. Neglect is defined as a failure to meet a person's basic physical, emotional, social, or psychological needs, which is likely to result in impairment of the person's well-being. Now, I wouldn't spend too much time worrying about that latter part, which is likely to result in impairment of a person's well-being, because it would only be a need within the meaning of the 2014 Act if, in fact, it did impair the person's well-being. When a local authority is asking itself whether it's satisfied that a person has a need for care and support to prevent abuse or neglect, paragraph 88 of part 3 of the Code of Practice says that the local authority must make reasonable inquiries. So when somebody comes to their attention, when the suspension is in place, or when they're considering withdrawing support to somebody who they currently provide support to, they have to make reasonable inquiries to satisfy themselves whether or not that person is at risk of abuse or in neglect. So it's apparent from all of that that a local authority still needs to meet an adult's needs if, without care and support from the local authority, their basic physical, emotional, social, and or psychological needs would not be met, and that this would impair their well-being. I just want to touch upon an example of when these basic needs might be engaged. So let's take an example of a young adult with learning difficulties who's at a residential college. And the residential college are meeting all of those basic needs as well as educational and training needs. That educational college may close during this coronavirus outbreak, and the Welsh ministers have a power to close residential colleges under Section 37 and Schedule 16 of the Coronavirus Act, if they are being funded by the Welsh ministers under the Learning and Skills Act 2000. So there may come a time when residential colleges close. What's going to happen to the young adult who's currently there on a residential placement? Well, either they're going to be returning home with their parents or to some other form of accommodation. Now, if we take an adult with, say, severe autism, that sudden change might be very distressing to that young adult. If it is very distressing, then that might be a basic emotional or psychological need that the local authority would have to meet. And so the local authority would have to pick up the residual responsibility to meet those needs if that person could no longer attend a residential college. And so those who are concerned about young people in residential colleges should be alive to the residual needs on local authorities to make sure basic needs are met. There's a tension in the 2014 Act as it's currently amended, because Section 145 of the Act requires the local authorities to act in accordance with the codes of practice, unless there's any other guidance issued by the Welsh ministers for the purpose of the Coronavirus Act changes. At the moment, there is no other guidance provided by the Welsh ministers apart from guidance on supported accommodation. I'll come to that in a moment. What that means is, at the moment, technically, under the Act, local authorities still have to comply with the Code of Practice, which is more demanding than the Act in its current form. However, what I would say about that is I'd be very cautious about going off to court and arguing that the local authority has to comply with the Code of Practice, which is more demanding, because in my view, it is likely that a court would read into Section 145 of the Act, which requires local authorities to have regard to the code and act in accordance with it. I think that they would read into that section the exclusion to mirror the fact that other parts of the Act are currently suspended. So whilst technically local authorities still have to comply with the code, I think a dose of reality is needed here, and that if part of the Act is suspended, it doesn't make any sense that they have to comply with a code that relates to part of the Act which is suspended. When the Welsh ministers publish guidance under the Coronavirus Act, then that will take precedence over the code, and the code will be displaced by the guidance. But as I say, at the moment, there isn't any guidance. The only guidance in place, available on the Welsh Government website, on the Coronavirus Update page, is guidance on supported accommodation. And so there are obvious issues in supported accommodation about social isolation, shared kitchen, shared bathrooms, etc. There's guidance in there. And there are two interesting parts of the guidance that I would like to pick out. Firstly, the guidance says that if it's not reasonably practicable for adults who've been being provided with care and support to stay in supported accommodation because perhaps they don't understand social isolation, then it's incumbent upon the local authority to provide alternative accommodation. And they may have to source alternative accommodation if it becomes necessary. And the second point that's of interest in that guidance is that the guidance says, where possible, social workers and other support staff will be provided with personal protective equipment. Now, of course, we know from the news that those on the front line of healthcare provision are not being provided with personal protective equipment. And so the if possible qualification in the guidance is likely to be engaged more often than not when it comes to frontline staff and supported accommodation. I've mentioned it already. It should be noted that the changes, the suspension being brought into force for the 2014 Act applies not only to new adults coming to the attention of local authorities, but also to adults who are already in receipt of care and support from local authorities. And that is paragraph 34 of Schedule 12 of the 2020 Act. And so it is open to local authorities to withdraw support that they are currently providing, subject, of course, to the residual duty to make sure that they don't expose that person to abuse or neglect, or a risk of abuse or neglect. That's what I intend to cover in relation to care and support in Wales. Hopefully, if any of you have any questions, please use the chat function to submit them. And in the final half an hour, you could also ask a question out loud if you haven't managed to do that. I just want to bring you to your attention just one final matter. For those who carry out civil litigation, there's a new practice direction in force, Practice Direction 51ZA, and that's a practice direction that allows parties to agree extensions of time up to 56 days without order of the court, so to provide for longer extensions whilst the coronavirus outbreak is going on. So I just thought I'd bring that to your attention as well. That's enough from me. The next speaker is going to be Michael Imperato from Watkins and Gunn. He's going to talk about education and special educational needs, together with Mark Allen. Michael Imperato is a preeminent claimant public law practitioner in Wales. He does lots of education, community care and local government work. And he's been in a number of important cases in the Court of Appeal recently. Mark Allen will be known to many of you. He has vast experience in special educational needs and mental health. He sits as a fee-paid member of the Special Educational Needs Tribunal in Wales and also the Mental Health Tribunal in Wales, and he is consistently recommended in the Legal 500 and Chambers of Partners recommendations. So, Michael, over to you on the subject of education.
Right, yes, thanks, thanks, Christian. People hear me okay? Yeah? Yeah. I'm going to try and share a screen here, so and with a PowerPoint. So this is going to be interesting. So I'll press the share screen, and right. So hopefully people can see that, and we're going to go. So, can people? I'm assuming everyone can see the PowerPoint. so educational provisions. The bill includes three powers. The first one I'm going to look at is a power to require or direct the temporary closure of institutions. Basically, it does what it says on the tin, really. Everything is in clause or parts 37, 38. That's the area of the bill where a lot of this information is. And and Schedule 16 and 17 towards the end of the bill, again, that's where a lot of the detail is. So those are the areas you want to be looking at. And England and Wales have got very similar provisions for England and Wales. And so they often are really just one clause apart for England or for Wales. Before directing the closure of settings, the Welsh ministers must have regard to advice from the chief medical officer or deputy medical officers, and they must be satisfied that it's necessary and proportionate action. And that's a phrase which you'll see repeating a few times. It can also be delegated. They can delegate their powers down to local authorities or for higher education, the Higher Education Funding Council for Wales. So be aware of that. There's a delegation power as well in all this, in respect of the initial powers. Temporary continuity directions. This is a power under the Act to make specified types of directions. They're called, so that say the catchy phrase for these is temporary continuity directions. So look out for this becoming a common phrase, a TCD or something like that. It'll become known as. This is now clause 38 in Schedule 17. So you see they're all one clause and one schedule along. And it gives powers to direct providers to continue to stay open, but to make certain types of provisions. And this could include tweaking education or tweaking training or childcare services, ancillary services. So this gives that flexibility. Examples could be directing an institution to stay open or to change its opening times, alteration of dates, term dates, alterations of transport provisions. So this is what gives the Welsh ministers and local authorities a lot of flexibility in dealing with the situation on the ground. Again, the power can be delegated, and again, similar that the power when they exercise this, it's got to be on a medical advice and necessary proportionate action. So this is the thread that runs through the educational provisions, really, what we're talking about. Probably the most interesting one is the power to disapply or modify. So this is disapply or modify specified existing legislative requirements. So the bill gives the government these powers. These are intended to enable schools and other institutions to operate effectively without undue burden in an emergency period. So it's basically relaxing regulation effectively. It basically gives powers to require institutions to stay open or relax requirements around legislation. This could include reducing teaching ratios, adapting school meal standards, and most interestingly, relaxing provisions for those with special educational needs. Disapply, so we have two things, disapply and modify. Disapply means that obligation is wholly removed, it's swept away. Modify means again what it says on the tin, that it's changed, and the change though is subject to a reasonable endeavour's duty. Okay, so it's the duty's not swept away totally, but it's that proviso that there's a reasonable endeavour's duty now to meet that original obligation. And so the legislation sets out a list of things which will be disapplied. That's the first paragraph there, and then sets out the things which would be modified. So modified, for example, could be regulations about collective worship, SEN provision, school meals, attendance numbers, those kind of things. So this is an area, this disapply modify area is an area of concern, particularly in respect to special education needs, ALN. It gives them powers to effectively downgrade the local authority education law duties. It downgrades them from absolute obligations to reasonable endeavour obligations. So so thus the local authority will merely have to show their views of reasonable endeavours to discharge the duty, which clearly creates a much lesser entitlement for the recipient. So this is the significant, profound shift, especially in special education needs matters, where, well, as I say, absolute duties are currently downgraded. So at the moment, if a local authority is failing to maintain the old-fashioned statement of special needs, they are failing to give speech and language provision or something, then you can basically take that to court, judicial review, and it's a slam dunk winning case in a way, because it's an absolute duty to do so. But now it'll be, well, if this comes in, it will be a question of, well, the local authority are using their reasonable endeavours to supply it. It's not something which is wholly obliged to. So these education powers are in force, but in respect of these key education law duties of disapply and modify, it's triggered by a notice. So it's not, so the disapply modify is not in effect as we speak today. Well, not what I'm aware of. I'm not aware of any notices being issued yet. So it's triggered on issue of the notice, and the notice must state why they consider they're issuing the notice, and it has to be an appropriate and proportionate action in the circumstances. So that's the rationale for the notice, which then disapplies or modifies the obligations. So a critical question is, what is the threshold for that notice? How bad do things have to be? Well, there's no real guidance in the Act other than those words appropriate and proportionate. In England, the Minister for Children, Vicky Ford, sent out a letter saying the powers would only be exercised where necessary. That doesn't really take us any much further forward, and I'm not aware of any further guidance or pronouncements by the Welsh ministers. So we are more or less left with those words appropriate and proportionate. And the length of the notice, it must not exceed 1 month. Okay, so the notices would be for that limited period. As I say, until the notices have been issued, these rights are not applied. Final point is, this time of year, local authorities and people like me are actually very busy doing admissions appeals. That's the kind of normal thing that kicks off in April, May. So interestingly, I don't think the powers, these should be affected by any of this, because the actual Act says that appeal panels are counted as local government meetings, and the Act at paragraph 7, at section 78, gives powers for certain local government meetings, of which admissions panels are expressly named as one, to be conducted virtually. So I think, in a way, therefore, admissions hearings, technically, there's no reason why they still can't be going ahead on a virtual basis. Provision is made for that. Okay, so that's my bit. I hope you found that useful. So I will stop sharing now. Thank you.
Right, and I will step in. Can you see me now? Yeah, okay, thank you very much, Michael. You'll note I'm the only speaker that has a halo. I'm not sure if that gives any great gravitas to what I'm about to say, but I thought I should point it out. I'm just going to say a few words about the effect upon the two tribunals I sit on and where they both are in terms of these current changes. And one or two other general things about remote hearings, which of course is the brave new world. I have to say what Michael's just been speaking about are matters of grave concern in terms of special educational needs, I suspect, for many. Quite what the practical repercussions will be for parents who have children with special educational needs, in particular those that have residential accommodation. Goodness only knows, it's going to be very complicated and I suspect rather scary. So there's, I think, general concern at the moment about the relaxation of the duty, the clearly understood duty at the moment on local authorities. I appreciate there's the reasonable endeavours test which may replace it, which Michael's just been referring to, but it's plainly a watering down of the current absolute duty. The issue, I think, will be if parents wish to challenge the decisions made by local authorities, whether or not there's still going to be a matter which can be judicially reviewed. And I suspect it can be, because, of course, that word reasonable, as ever, comes in. And reasonableness, as you will know, is something which is critical to judicial review applications. So I think if local authorities are going to try to water down these provisions, if they're going to try to do it, they need to be very careful. They need to have an evidence trail of their decision making, and they may have to make sure they've applied all the guidance. Otherwise, they're going to give themselves difficulties. I think, to be fair, thus far, Wales has been doing much better than England in supporting children with special educational needs. I'm sure you've all seen press reports of alarm in England in terms of the withdrawal of support even before we got to the coronavirus crisis. So far as the Special Educational Needs Tribunal is concerned, there has been a postponement at the moment of hearings. They will be continuing, I hope, in the not too distant future. What the tribunal is setting up is a system with virtual hearing rooms. That's been tried and tested. We had a very good chairs meeting with the President recently, conducted in fact by Skype on this occasion. And as a result of that, we were able to test out one of these virtual hearing rooms, and they're quite good. They're very similar to the Zoom and Skype for Business type scenarios. But the test was successful, and now I know that the Welsh Government has in fact ordered 20 of these virtual hearing rooms to be set up for use by the Welsh tribunals. That doesn't include the Mental Health Tribunal, as I understand at the moment. And it's intended to roll out these virtual hearing rooms, conduct oral hearings through those as normally as possible. And as soon as the position has become clear and that's available and up and running, everyone will be informed. It looks as though it's going to be at least another 10 days, I'm afraid, before that is up and running. The tribunal is still conducting directions hearings over the telephone or by Skype, and paper hearings in the usual way. And I just need to reiterate that the parties can request a paper hearing in any case if they wish to do so. Can I just mention one or two other things about remote hearings, because obviously they are going to be the way that we're going to go. Skype for Business and Teams have been used successfully, I think, by a number of people. But the big issue there is whether they can be accessed by those who don't have business addresses. And I don't know the answer to that at the moment. I know it's been a considerable difficulty that's been met. And I think that the big problem throughout all of this wonderful techie world we're entering is how we're going to ensure that the people at the heart of these cases, the parents or the patients or the relations, the parties, are going to actually successfully access these hearings. Zoom also has been used. We had a very good Family Law Bar Association Zoom meeting for 2.5 hours last week. It's good because it's got a waiting room facility, which I think you've just been experiencing. And also you can have breakout rooms. So you can push the parties, their legal representatives, into a separate room where they can't be overheard. They can have their own private conference and then be brought back into the hearing subsequently. There was an issue, I know, on social media about whether Zoom was GDPR compliant. As I understand it, the government is satisfied, or I say that the UK government is satisfied that it is. And so that the problem has been that the tech isn't available to the judiciary as yet, but I think that's moving. I also just mention, of course, that if you're going to be using these, you will need to have electronic bundles. And in respect of this, at the moment, the Special Educational Needs Tribunal in England is way ahead. They already have set up their virtual hearing rooms. All their hearings will be virtual hearings, and all of their hearings will be paperless, and they're the first legal organisation that's managed to get that set up, as I understand. So congratulations to them. But someone's got to prepare the bundles, and so I suspect there's going to be more work placed upon local authorities to produce an electronic bundle that is capable of being indexed and searchable. Adobe Pro and PDF Expert are obviously two of the programs which are commercially available, but there are others. But I suspect that in order to be able to use them at a hearing, you've got to be able to search them and get the page up immediately. And of course, we're working towards everybody being able to see the page at the one time. It can be done in hearings because it is already being done in hearings, but it requires rather more tech and know how to set it all up. Can I also go back to the problem of laypersons' perceptions? There's been some feedback also recently about how these hearings are perceived by the parties. And interestingly, I thought it was interesting, lack of formality has been an issue for them. They don't feel that it's a proper hearing, possibly because we're all a bit more relaxed because the judge and us are not within striking distance. I don't know, but it certainly appears to be the fact that they like it to feel like a courtroom to a degree and for it to feel like a proper hearing. And in addition to making sure we've included them, we've got to include them so that they have the right feel, I think, for the hearing. And one other mention about remote hearings, because it might fall upon in particular local authorities, is that generally they are going to be recorded. Now this is just a tribunal which I'm talking about, but other court hearings as well. And sometimes the person who's going to be responsible for recording it is the applicant who set up the hearing. And these recordings are going to have to be held at the court's or to the court's order and securely, but there's going to be potentially another duty upon local authorities and their representatives in terms of approaching those hearings. Well, that's all I'm going to say just for the moment. I'll come back and talk about the mental health review tribunal in due course, but now I'm going to hand, I think, over to Laura.
Hi everyone. So I'm going to deal mainly with mental health. I'm going to touch very, very briefly on mental capacity. And the reason for that being so brief is going to become apparent because we've got the Coronavirus Act 2020 now. And Section 10 relates to both mental health and mental capacity. However, in Wales, there are no changes to the Mental Capacity Act and no changes to the Deprivation of Liberty Safeguards procedures or to any other aspect of the Mental Capacity Act. The only changes relate to the Mental Health Act. I'm not entirely sure why that is, but I'll go into that later in terms of how DOLs are going to be dealt with. But I'll start firstly with the Mental Health Act and the changes to them. Just to quickly note, none of the paragraphs I'm going to refer to are currently in force. We're still waiting for regulations from Vaughan Gething to come through to make sure that those come into force. But these are going to be the schedules relating to the Mental Health Act and the amendments to it when we get those changes through. So I'm going to very briefly share my screen so we can have a look at the PowerPoint. And also just to say, I have got, can people see my screen? I don't know. No, can you see my screen?
No, you need to go to the bottom and click on share, the green box on the bottom.
Screen.
Sorry.
Can you see that, Laura? Do you want to
sorry. I just need to. I've worked out what it is. I need to grant access through my computer. I'm very sorry about that. It's only just come up. Also, while I'm waiting for my computer to grant access, I do have all of this in some notes, which are quite extensive and go through everything. So don't worry too much about getting the specifics because I've got them all.
Has that worked, Laura? Because I can share it from my screen if not.
Yeah, if you could share it from your screen, that'd be absolutely. Yeah, that'd be lovely. Or I can just do it without the PowerPoint. It's not a problem. They can just be circulated.
I'll just flick it through. That's fine.
Thank you. Okay. Yeah, I'm sorry, I can't share the PowerPoint.
If you start, Laura, I'll catch up with you.
Okay, so if I could start firstly with applications for compulsory admission to hospital for assessment or treatment. So applications under Section 2 or Section 3 of the Mental Health Act. I'm sure we all know at the moment we need 2 registered medical practitioners who need to prepare reports in relation to nature and degree, mental disorder, and all of the different requirements under those sections. This has been relaxed, so we no longer need 2 registered medical practitioners, but these applications can be made with a report from a single registered practitioner if it's considered that complying with the existing requirement would make it impractical or would involve undesirable delay. So that's the test if you want to reduce from 2 medical practitioners down to a single registered medical practitioner. And again, that test is probably going to come through quite a lot during this presentation, because that is the test for many of the requirements under the Mental Health Act to be relaxed. But however, the general provisions as to the medical recommendations that are set out in Section 12 of the Mental Health Act still apply to a single recommendation, as they would to a dual recommendation from 2 registered medical practitioners. So really the only relaxation is from 2 to 1. So if I could go to the next slide now, thank you. So I'm just going to go now on to applications for compulsory admission to patients who are already in hospital under Section 5. So where we've got a patient who is an inpatient in hospital and it appears to a registered medical practitioner or an approved clinician in charge of treatment of the patient, this is under Section 5. So this is the normal provision. Normally you have to have the person who's in charge of treatment that has to recommend that an application ought to be made under that part of the Act for their admission to hospital. They may furnish a report. However, in the Coronavirus Act 2020, this has been relaxed, and it doesn't have to be the person who's in charge of treatment, but it can in fact be any approved clinician who can furnish the report for the purposes of Section 5, subsection 2. And again, it's the same test. It's if that would prove impracticable or involve undesirable delay for it to be the person who's in charge of treatment. Section 5 is further amended in that for preparation of that report, normally under Section 5, there is only the power to detain that patient for 72 hours in order for that report to be furnished. However, that's now been increased to 120 hours. And again, Section 5 is further amended because under subsection 4 of Section 5, in the case of a patient who's receiving treatment as an inpatient and it appears to a nurse that the patient is suffering from a mental disorder and that nurse feels that there needs to be an application, but it's not practical to secure the immediate attendance of a practitioner to furnish a report under Section 5, normally the nurse will have the power to detain that patient for a period of 6 hours. Again, that period is now extended and it's doubled. The change to Section 5, subsection 4 is now that it's increased to 12 hours. In terms of Section 5, that is as far as we'll go in terms of Section 5. Those are the only changes. So as I say, where I'm setting out the changes, other parts of the Act apply to those parts as though those new words were read into them. Turning to Section 35, which is where we've got patients who are concerned in criminal proceedings who are under sentence, the court has the power to remand to hospital for report a mental condition. And again, it's changing the periods of detention. So normally an accused person can't be remanded under that section for more than 28 days at a time or for more than 12 weeks in all. So that backstop is there that you can only have a maximum of 12 weeks of remand in a mental health hospital. That provision has now changed, so that that backstop is removed. So the wording of section 35, or for more than 12 weeks in all, those words are now omitted into the Coronavirus Act 2020. Same in section 36, which is a remand of an accused person to hospital for treatment. Again, there's a backstop there of 12 weeks in all. That backstop has now been removed under the Coronavirus Act 2020. Again, continuing with patients concerned in criminal proceedings, there are several sections at the moment under the Mental Health Act 1983, which give the criminal courts the power to detain an accused or a convicted person in hospital. And those are sections 36, section 37, 38, 45A and 51. And those are various powers to remand for treatment, orders for detention in hospital, guardianship, order for interim detention, order for a person to be sentenced to imprisonment detained in hospital instead of prison, and the power to order detention of a person in hospital in the absence of the person. So those are the various powers currently available to the criminal courts under the Mental Health Act. And again, all of those reports require 2 medical practitioners to prepare reports, and for 2 practitioners to confirm that the requirements into those sections are made out. Again, it's the same as under applications for compulsory admission under sections 2 and 3. If it is considered that complying with the existing requirement, which requires 2 medical practitioners to make an application, is impracticable or would involve undesirable delay. So it's that same test again that was used earlier, which applies to patients concerned in criminal proceedings or under sentence. And under sections 47 and 48 of the Mental Health Act, as it is at the moment, these contain provisions about moving prisoners. So these might be serving prisoners, they might be other prisoners who are on remand, and there are different requirements from reports for at least 2 medical practitioners that the person suffers from a mental disorder of a nature or degree which makes it appropriate for them to be detained in hospital. So again, moving between prison and hospital when they're on remand or under sentence, the Secretary of State has the power to do that under the Mental Health Act, but only where they've got a report from 2 medical practitioners. Again, it's exactly the same. That is effectively being relaxed so that it can be from just 1 registered medical practitioner, again, if that same test is made out. And finally, when it comes to patients under criminal proceedings or under sentence, the Mental Health Act sets down various time limits for detention and movement between court, prison and hospital sections. So section 35(9) has the power to remand a patient to hospital for a report on the accused's mental condition. However, there's a time limit of 7 days. Again, section 40, subsections 1 and 3, there are various different time limits depending on the type of order. So hospital order, 28 days, guardianship order, 14 days, interim hospital order, 28 days. Everything that I've set out there in terms of section 45B as well, which again has a time limit of 28 days, all of those so have a fail-safe mechanism now within the Act, which sets out that the transfer, conveyance, admission should take place within that period or as soon as practicable after the end of that period. So where previously there was an absolute time limit on those matters taking place, now there's a fail-safe mechanism that if it is not practicable within that time limit, then it can be later, but as soon as practicable. Finally, section 47(2), which is the period within which person subject to transfer direction must be received into the hospital, that's got a time limit now of 14 days under the Mental Health Act, but under the Coronavirus Act, that has been amended so that it's 28 days. And as I say, I've got notes which sets out all in detail. So if you're confused about the amendments, which is 14, which is 28, it's all in the notes. So that's it in terms of patients who are under criminal proceedings. I'm going to move on now to administration of medicine to persons liable to detention in hospital. So under section 58, where a person requires treatment and that treatment needs to be consented to, or there needs to be a medical opinion, normally there's a procedure for that consent being obtained, or a registered medical practitioner providing a second opinion. So when 3 months have elapsed since the treatment started, that treatment can only be administered with the patient's consent, or if the patient doesn't consent, a registered medical practitioner who is neither the registered clinician or the approved clinician in charge of their treatment has given a certificate confirming that the patient is either not capable of understanding the nature, purpose and likely effects of the treatment, or is capable but has not consented to it. And they must conclude that in either case it's appropriate for that treatment to be given. And further, subsection 4 of that section requires the registered medical practitioner to consult 2 other persons who have been professionally concerned with the medical treatment. For neither of those persons, one of those persons must be a nurse, and neither shall be the registered clinician or the approved clinician. So effectively, a provision requiring an independent opinion in relation to a patient who's not consenting to treatment. However, under the Coronavirus Act, those matters are now relaxed. So if the clinician considers that complying with the requirement for the certificate to be given by a registered medical practitioner other than the approved clinician or registered clinician is impracticable or would involve undesirable delay, so again, exact same test being trotted out through all of these paragraphs, then that provision is relaxed. And the approved clinician may give a certificate under that section. And if that approved clinician, rather than consulting with 2 other people, they can now only consult with one other person. But that one other person must have been professionally concerned with the patient's medical treatment and must not be a nurse, a registered medical practitioner, or the registered clinician or the approved clinician in charge of the treatment in question. So there is still that provision for a degree of independence, even though it's clearly relaxed. Finally, in terms of amendments to the Mental Health Act, we've got detention in place of safety. So currently there's a time limit of 24 hours, and under the Coronavirus Act, that time limit is simply amended to 36 hours. Just to sort of give you a little bit of an update in terms of where we are, NHS England and NHS Improvement are currently preparing detailed guidance setting out the exact circumstances in which such powers would be used. And that's in response to concerns raised during the bill's passage through Parliament about the effect of the legislation on the existing deprivation of liberty safeguards. I'm going to move very briefly now on to doles and mental capacity. I don't want to overrun too much. The government confirmed that it did not intend to amend the safeguards in primary legislation. It's instead going to publish emergency guidance, making it clearer when deprivation of liberty safeguards authorisation is necessary and the basis on which an assessment can be made, including, for example, phone or video calling for an assessment. However, that guidance has yet to be issued. There is some non-statutory guidance that's been issued, and again, I've referred to it in my notes, but it's very, very broad brush. It doesn't really, in my opinion, help people on the ground because it sets out basic principles rather than giving people practical guidance that they can really work from. So, albeit the Mental Capacity Act and the Deprivation of Liberty Safeguards haven't been amended by the Coronavirus Act, it's clear that we're now going to have to apply these existing acts in a different context. So we've got to continue to apply the core principles, but it's clearly going to be require some creative thinking from professionals on the ground. Because, for example, I can think of a particular example where we've got someone who's currently in the community, being cared for in the community, may have a package of care, may simply have come to the local authority's attention, and they are not complying with social distancing rules. What happens when it's clear that they need to comply with social distancing rules and the regulations that are in force in order to keep them under the safe, but they're not doing so? How is that going to be managed? Well, just telling someone that they can't do it because it's against the regulations may not be enough. It may be that it's considered that continuous supervision and control is going to be the only means necessary to ensure that person stays inside. Well, clearly that's going to meet the acid test in Cheshire West. And it's going to have to involve some serious thinking about whether or not it's proportionate to put in place a standard authorisation, and indeed whether or not that person has capacity to consider whether or not it's in their best interests to leave the house and fail to comply with the regulations. So I can't really talk much about that, but those are sort of the general issues that I'm throwing out there that are clearly going to become prevalent in the current climate, because we may have scenarios where there are effectively situations where there's deprivation of liberty in the community, and the local authority is going to have an enormous job on their hands really to try and manage that. So at the moment I can't give any specific answers on that because we haven't got any statutory guidance. We've got some non-statutory guidance which I've referred to here in my PowerPoint, but as you can see from the parts that I've quoted, they are very broad brush. They don't really give any practical guidance to people on the ground. There is some further clinical guidance which has been published by NHS England. I haven't been able to find anything specific to Wales, and as this is non-statutory guidance, it clearly is, it may be useful to practitioners, but it's not statutory guidance. So that concludes my talk. I'm sorry if I've gone over. As I say, there are lots of notes that I've circulated which have all of that in detail. So I'm going to hand now back over to you, Christian.
Thank you very much, Laura Shepherd. And I should say that Laura joined Chambers in 2017 and is quickly developing a strong public law practice in the areas of licensing, education, quarter protection, and immigration. So that's education and mental health covered. Our final speaker on the topic of police powers is David Hughes. He's an experienced police and public lawyer. He's a committee member of Public Law Wales and was asked to give evidence to the Thomas Commission on the devolution. He's also an elected member of Liberty's National Policy Council, and he has particular experience in mental health and quarter protection as part of his public law practice. David, on police powers, thank you.
Hi, just unmuted myself. Can everybody hear me? Yeah, I'm getting nods on the screen. Okay, as Christian's introduced me, I'm David Hughes, member of the team at 30 Park Place, and a lot of my work involves representing claimants in civil claims against the police. There's been a lot of commentary on social and other media about the police powers under the coronavirus legislation. Some of it has even been informed commentary, but almost all of it has related to the English regulations. There are separate Welsh regulations which do contain some differences. Most of the speakers have spoken to you about the Coronavirus Act. The principal piece of legislation I'm going to speak to you about is the Health Protection Coronavirus Restrictions Wales Regulations 2020, which came into force on the 26th of March at 4 p.m. That was several hours later than the English regulations came into force on the other side of the border. I will come to the Act later on. I'm conscious of time and the need to allow some time for questions and answers at the end. But the first piece of legislation I'm going to talk about are the regulations. These are made under the Public Health Control of Diseases Act 1984. Interestingly, even though they're made by the Welsh ministers, they're only available in English. And important first point to note about them is that although I've describing them as police powers, the powers provided for by the regulations are not merely exercisable by constables, by people we would normally consider to be police officers. They can be exercised by police community support officers, by persons designated by the Welsh ministers, persons designated by local authorities, or by a national park authority in Wales, or by Natural Resources Wales. Now, there are restrictions on how someone designated by, say, Natural Resources Wales can exercise their powers, but it's broader than just police. And the number of people who can exercise these powers is broader than their equivalent in the English legislation. Something to remember if you hear or read commentary about the English regulations. In England, for example, a national park authority can't designate somebody. The term used in the regulations for someone who is designated is a relevant person. So we'll go through some of those powers, and they are found in Regulation 10 of those regulations. Sorry, I didn't have time to whack up a PowerPoint for you today. Regulation 10.1 gives power to give a prohibition notice to a person if a relevant person reasonably believes that that person is contravening Regulation 4, which is about closing businesses and premises, Regulation 6, restrictions on other businesses and premises, or 7, restrictions on places of worship or similar, and it is necessary and proportionate to give the prohibition notice for the purpose of preventing that person from continuing to contravene the regulations. So there must be a belief that the regulations are being breached, and that belief must be reasonable. The issuing of the prohibition notice must be necessary and proportionate to prevent the person from continuing to contravene the regulations. That's a high test. Those of us who do police cases often see cases in which arresting officers, and in particular custody officers, take a rather relaxed view as to necessity when that's used as a requirement in case. For example, when continuing to authorize detention at a station. But the case law tells us that it is not a synonym for desirable or convenient. It is a high test. And it's not enough that the prohibition notice be necessary, it must be proportionate. For example, if a serving of a prohibition notice were necessary to prevent a continuing breach, but were disproportionate, then the requirements of the regulations would not be met. It also talks about the purpose being preventing the person from continuing to contravene the regulations. So any continued contravention must be by the same person. That should be read with a caveat in that these provisions apply to bodies corporate and to unincorporated associations. So my view at this stage is that a contravention by different members of the same unincorporated association would probably entitle the service of a prohibition notice. What about a contravention that stops and then resumes, for example, opening a shop? Well, the regulations speak of continuing to contravene, which is not necessarily the same thing as a single continuous contravention. I think if you try to argue that a prohibition notice was not properly given because there was not a single continuous contravention, I think you would be, I think such an argument would be unpromising. Regulation 10.2 provides that if you're breaching 8.1, Regulation 8.1 is the general prohibition against leaving your home, a relevant person may direct you home and may remove you to your home. So they can physically take you home, or they can ask a constable to take you home. This power can only be exercised where it's necessary and proportionate means of ensuring compliance. Note the absence of any express requirement in that latter provision I've been talking about, that the view of the relevant person be reasonable. There is some risk that a rash police lawyer will argue that Liversidge and Anderson is still good law. and that an unreasonable belief will suffice, or rather that it is for the relevant person to decide whether their belief is reasonable. I think we can confidently say that such an argument would be wrong, but given what we've seen in a certain magistrate's court over the border recently, we can't say that it won't be tried. Regulation 8 is our equivalent of what is Regulation 6 in the English regulations, and that's attracted much comment. Regulation 8.1, as I mentioned a few minutes ago, provides that no person may leave the place where they are living without reasonable excuse. 8.2 provides that reasonable excuse includes the need, followed by a list of activities. Now, as has been much commented, includes means that the list that follows is not an exhaustive list. The fact that something isn't on the list does not mean that it isn't a reasonable excuse. Another commented feature of this is that the prohibition is on leaving the place where you live, not being outside it. So if you leave with a reasonable excuse but remain outside without one, on the face of the regulations, you're not breaching them. However, you've got to be realistic about this. If your excuse for going outside is that you're going shopping for necessities, for example, but you left home several hours ago, you've done no shopping and are nowhere near a grocery store, it might indicate that the shopping bag you're carrying is a disguise. I think that there is probably going to be some flexibility about this, so that if you remain outside for after the reasonable excuse is no longer realistic for you, I think we may find the regulations being given a slightly expansive interpretation there. There's the famous bit regarding exercise, which is much commented because the regulations for the other nations don't mention taking exercise outside once a day. The Welsh regulations do mention that. It's a subject close to my heart, as I'm a bit of a fitness fanatic. But of course, the list of activities that constitute a reasonable excuse is not exhaustive. So it's possible, for example, that if you go for a run outside in the morning, you might still be able to go out and supervise your child while they're having a bike ride. No more than once a day does feature in the Welsh regulations, unlike those of the other nations. Fortunately, the provision against leaving the place where you usually live does not apply to the homeless. So there's been some careless drafting, but they have got that in, which is important. There's been discussion as to where the burden of proof would lie if one of these cases goes to court. The Scottish regulations say that the burden is on the defendant to prove reasonable excuse. I think the better view in Wales is that it would be for the prosecution to prove an absence of reasonable excuse. There may be an evidential burden on a defendant to raise it, but I risk straying there from police powers into substantive criminal law. So the police can give you a prohibition notice, they can direct you home, and they can remove you to your home. What else can they do? They can direct you to follow such instructions as they consider necessary and use reasonable force in the exercise of that power. Again, the word reasonably is absent in what they consider necessary. It's such instructions as they consider necessary, not as they reasonably consider necessary. That is almost inevitable. We can say with real confidence that that is going to be subject to a reasonableness requirement. The test will be, what did the officer know? Did he have a requisite belief that what they were telling you to do was necessary? And if so, was that belief reasonable? Again, Liversidge and Anderson arguments may be raised. I don't think they will have any real prospect of succeeding. They can direct you to take home a child for whom you have responsibility. And if you are given directions, you must, as so far as you reasonably can, ensure that a child complies with any instruction given to it. So, for example, if the police use their power to give instructions to a child, and you're an adult who has responsibility for that child, you must try and ensure that the child complies. Again, the power to take a child home or ensure it complies with instruction is exercisable if the relevant person considers it a reasonable and proportionate way of ensuring compliance. Again, no reference to that consideration being reasonable, but you've heard what I've said about that. Where 3 or more people are gathering, a relevant person can direct them to disperse, can direct any of them to go home, and can again remove them to their home, again subject to that being necessary and proportionate. There is some suggestion in the regulations that the necessary and proportionate requirement applies more broadly to the powers in Regulation 10 than just to those that mention it expressly. To go into a full explanation of that would take me way beyond the time limit, so I'm not going to do it. I'm simply going to flag it up for you as something to watch out for. You can be removed from a public path or access land which is closed, and a relevant person can use reasonable force to do so. And Regulation 10.10 reads rather ominously that a relevant person can take such other action as he considers necessary and proportionate to facilitate the exercise of a power conferred by Regulation 10, what I'm talking about now, or Regulation 11. Regulation 11 provides for a power of entry. If we're being glib, we might think that's a little strange, as the regulations are about making us stay in rather than making us go out. But if you think about it, it might well be important, for example, for breaking up parties, gatherings, that sort of thing. It is an offence to contravene these regulations, punishable on summary conviction by a fine. Section 24(5) of PACE, which provides for the reasons why an arrest can be lawful. An arrest can be lawful, for those of you who aren't familiar with this law, if it's necessary for a number of reasons. And insofar as offences under the regulations go, the reasons are to be read as including to maintain public health or maintain public order. Regulation 13 provides for fixed penalty notices. The amount is fixed at £60, 120 if you've already had a fixed penalty notice. There's a £30 discount on your first fixed penalty notice if you pay within 14 days. There's no provision for appealing fixed penalty notices. If you're aggrieved about being given a fixed penalty notice, it may be that the proper course will be a judicial review. There may be interesting arguments about the scope of a review possible on JR, as it's going to be difficult to deal with any application to quash a fixed penalty notice without getting into factual disputes. Now, the courts may take the attitude that as the effect of failure to pay a fixed penalty notice is simply to expose yourself to prosecution, there is an adequate alternative remedy open to those who receive fixed penalty notices, which is to await prosecution and challenge the facts in a criminal trial. No prosecution can be brought other than by the DPP or a person designated by the Welsh ministers. So that appears to make private prosecutions, at least private prosecutions by people who haven't got the okay of the Welsh ministers, unlikely. Regulation 12.3 is one that carries, I think, a significant risk of litigation. That provides that it is an offence to not comply with, inter alia, a prohibition notice. So if you're given a prohibition notice, what do you do? Well, as with fixed penalty notices, there is no provision for appealing a prohibition notice. Can you challenge it in court if you're prosecuted for failing to comply with it? Well, this is something that causes me a little bit of concern. In planning prosecutions, which seem to me to be a little bit comparable, you have to challenge an enforcement notice when it's issued. You can't simply wait to be prosecuted and then challenge it when you are prosecuted. Now, I think that can be distinguished from the current, from the regulations, because planning enforcement notices, there is an appeal procedure provided for, unlike here. It is possible, I think, to seek a judicial review of a prohibition notice. That would present challenges for the administrative court because, as with a fixed penalty notice, it's likely to involve a factual investigation. I think the administrative court will, for that reason, possibly not be keen on saying that you've got to go by this way, that you can't challenge it in the magistrate's court. That consideration, plus the absence of any appeal mechanism, leads me to believe that you will probably be able to challenge it in the magistrate's court if you are prosecuted for breaching it. But a cautious receiver of a prohibition notice might well want to seek a judicial review of that. And it will be very interesting to see how that would pan out. That's what I was going to say about the regulations. About the Coronavirus Act itself, when you read the index of it, you might be tempted to think that the extension of police powers is less evident there. It is there, but it's somewhat hidden. There's a mention in the substance of the Act to a power to extend the period of time for which fingerprints or DNA material can be held. Related to this, at least a related practice area for many of us, is the fact that the Act makes coronavirus a non-notifiable disease, meaning that a jury is not required in any inquest. But the real extension for police powers in the Act is in Schedule 21. Now, any act that has 21 schedules, that isn't a great sign. And it provides for measures that can be taken vis-a-vis potentially infected persons. There are different parts of this schedule for the different parts of the UK, and the Welsh bit is Part 4. It allows the Welsh ministers to make a declaration that the incidence or transmission of coronavirus constitutes a serious and imminent threat to public health in Wales, and that the powers conferred by that part will be an effective means of delaying or preventing significant further transmission of the virus in Wales. So it requires the Welsh ministers to make a declaration. That in itself opens up the possibility of challenge by judicial review. So it's a declaration that triggers these powers rather than the Act itself, although the powers themselves are in the Act. There are numerous powers here. The police can, well, a public health officer can direct you to go to a suitable place for screening and assessment and request the assistance of a constable taking you there. They can do it if the officer considers that it's necessary and proportionate in the interests of the person, for the protection of other people, or for the maintenance of public health. No reasonableness there. Again, you've heard what I've said about that. Constables and immigration officers have a similar power. All of them must tell you that it's an offence not to comply or to abscond once you've done it. You can be required to remain at the assessment place for up to 48 hours. They can require you to be assessed. Note that this is primary legislation. One can foresee certain Human Rights Act problems here about Article 9, in addition to other articles. They can direct you to provide a biological sample, to allow someone to take a biological sample, and to answer questions and provide information. You can be directed to go to another place. You can be kept by a constable for up to 48 hours or by an immigration officer for up to 3 hours, pending a public health officer directing you to an assessment centre. These periods can be extended by 24 hours in the case of the police and 9 hours in the case of an immigration officer, with the agreement of a senior officer, being a superintendent or a chief immigration officer. They can do that if it isn't reasonably practicable for the public health officer to exercise functions within the original time. Where you've been assessed and the assessment is inconclusive, or the officer has reasonable grounds to suspect that you are potentially infected, then there are very broad powers. A public health officer may at any time during the transmission control period impose such requirements and restrictions on the person as the officer considers necessary and proportionate. No reasonably considers necessary, again, whenever considers is not accompanied by reasonably. I think we need to read reasonably into that. Otherwise we get into Liversidge and Anderson type territory. The powers are, as I say, pretty broad. They can direct you to impose, they can impose such requirements and restrictions as necessary and proportionate. You can be required to remain in a place in isolation or otherwise for up to 14 days, must be assessed within 48 hours if that is done. That can be extended. As I read paragraph 59.6 of Schedule 21, it says that save where the requirement is to remain in isolation, it can only be extended for up to 14 days. That strikes me as very bizarre in that it suggests that the direction to the requirement to remain in isolation can be extended for longer. So a more restrictive requirement is subject to less onerous restrictions on when it can be extended. An extended period must be assessed every 24 hours. Contrast the position to the regulations. There is provision for an appeal against a paragraph 58 order, which is an order made after assessment. Appeal is to the magistrate's court. Final thing I'm going to say on this, there is no requirement that any of the requirements that can be made of you under this schedule be in writing. They can be made orally, and the offences are summarily triable only. There is NPCC guidance on the English regulations. Note that they are only relevant to the English, or only expressly said to refer to the English regulations. So if you read them, take that into account. I realised I've gone at a certain pace, but we were a little bit behind, and I'm going to stop now and leave for questions.
Thank you very much, David. I'm a terrible host, and I was meant to go back to Mark after Laura Shepherd finished her talk, and so I'll do that now. Mark, with your update on mental health, thank you.
Thank you very much, Christian. I'm still muted. Hello, can you see me now?
I can see you, yeah.
That's lovely. Thank you very much. Yes, I just wanted to say a few quick words, principally at the Mental Health Review Tribunal position at the present time. There's been a practice direction recently issued by Carolyn Kirby, the president. I recommend if you use the tribunal that you have a look at that. It's again derived out of the difficulties which medical staff in this particular situation are having. They are very stretched. I was sitting with a psychiatrist this week who told me that in his particular trust, there's no longer separate rotas for separate disciplines. They're all going to be on one rota on an emergency basis fighting the coronavirus. So already it's getting pretty dire. But that means, of course, it's very difficult to set up hearings for mental health review tribunals, and also very difficult to get into hospitals. And so with that in mind, the practice direction has already ditched preliminary examinations by the psychiatrist before the hearing. Those have gone. There will not be any, and that is to avoid spreading the virus and going into hospitals, etc. It also empowers at the moment the tribunal to dispense with hearings altogether if it has sufficient evidence. So that is, again, pretty draconian, but I hope won't be used very much. There's been a brief postponement of hearings anyway, whilst remote hearings were set up and tested. But we are now conducting those hearings again. We started again this week. I did one yesterday, and so that should continue. There will, however, be an ongoing priority assessment of cases. So, for example, Section 2 is obviously going to be treated as far more urgent than, say, community treatment order appeals for obvious reasons. In England, also, they are actively reducing the number of members on the panel. There's power in Wales to do that if necessary, even to reduce it just down to the legal member. I hope that that is not going to happen in Wales. There is not a great appetite for it, as I can see so far. And if we can do it by remote working, by telephone hearings, I don't really see it's necessary. A couple of other things. Can I recommend something that Laura's mentioned in the chat, which is the directions of Mr. Justice Hayden so far as the Court of Protection is concerned, in particular the guidance issued on the 31st of March. Now, I know you're all sick to death of guidance of one sort or another, but what it does contain within that is some really sensible advice about hearings. Things like when you should be muted, when you shouldn't, when you should interrupt, how you're going to interrupt, preserving the dignity of the proceedings, those sorts of things. Also, very importantly, it stresses that if you're going to have conferences and talk to your own client, you've got to do it before the hearing starts clearly, so that you're fully ready when the judge comes in. Two quick things about security, and then I'm going to conclude what I want to say. One of them is there is clearly concern about security of hearings in general in terms of lay attendees recording them one way or another. And this is why at the moment there's been much discussion about whether someone should be sat with lay persons the whole time, ideally their legal representative clearly. That of itself causes all sorts of problems with the coronavirus currently. And most solicitors' offices, indeed barristers' chambers, are shut. So that's clearly very difficult. But can I just mention a word of warning, I think, that needs to be given to lay clients and indeed to family members of your own family if you're conducting these hearings from home. And that relates to Schedule 25, yet another schedule of the Coronavirus Act 2020. And that makes it very clear that you will be prosecuted if you record or try to transmit anything which happens in one of these hearings. So the lay person who sat at home and presses the record button is in deep trouble if anyone finds out. I suspect we will find out when it's on Facebook the next day. So it's going to be probably pretty difficult for them to say that they haven't done it. But think of the scenario where one of your kids comes in and sees mummy or daddy speaking on the television to other people and thinks it's clever to take a picture. One picture is enough, I'm afraid, to be a recording for these purposes and can result in prosecution. So be very careful, folks. It's dangerous out there. All right, that's all I wanted to say. Thank you very much, Christian.
Thank you, Mark. And we have a question for you straight off the bat from Sarah Porter. Is there any particular reason why mental health tribunals are not being held by video conference and only by telephone conference?
Yeah, so far they seem to be very wary of tech in the mental health tribunal. You'll be aware, I'm sure, that usually we don't use a lot of tech. In fact, it's back down to pen and paper. And that's partly because we don't want to trigger any reaction in patients. Now, patients also don't like things being recorded. It can feed into, obviously, psychosis and paranoia, etc. But at the moment they've decided to go by telephones, I think that's a great shame. Personally, I'd much rather do it so that we could see one another. I mean, I did a case this week with a learning disabled patient, and it was very difficult. We managed it, but it was very difficult, not least because you couldn't see whether he was reacting to what was being said at all. But at the moment, I'm afraid the President has decreed it's going to only be by telephone. I hope that there'll be some cross-fertilisation from other tribunals to show that, in fact, you can do it by video link securely and properly, and that we will do it that way. Thank you.
Another question from Gowan Williams, and this is for either you, David, or Laura, I suspect. In relation to COPDOL applications, and in particular, if there is no previous capacity assessment, will the court allow a consensus from professionals on the balance of probabilities? Anybody?
So I'm just reading the question.
So the guidance that's been issued, I've shared it in the chat and I'm happy to circulate it afterwards. It makes it quite clear, I think, that the judiciary are not going to be accepting much relaxing. For example, in the guidance that was issued by Justice Hayden, he made it quite clear that the judicial while there needs to be creative solutions to logistical problems, where applications are made for orders that P lacks capacity or interim orders on the basis that there is reason to believe that P lacks capacity, the court still needs to be satisfied of this. So there's not going to be any relaxation of the legal test to make, for example, interim orders or and particularly final orders under Section 15. So if applicants are entirely prevented by the pandemic from obtaining any evidence of P's lack of capacity but still seek an order, then they need to explain to the court exactly why the evidence cannot be obtained and exactly what it is the court is asked to do on an interim basis. So I hope that answers the question. In effect, there is no relaxation of the test. And the big problem, I think, at the moment is that the government haven't made any specific provisions for mental capacity in the Coronavirus Act 2020. And we're waiting at the moment on the statutory guidance, and all we've got really to go on is the guidance that's been issued from the Court of Protection. I hope that assists. I don't know whether anyone else wants to come in on that.
I'll take that as a no. Does anybody else from the attendees have any questions that haven't been put on the group chat? Just feel free to unmute yourself and ask the question.
If there are any questions, I did put my email address down in there. I have another event straight after this one, so what I will do is edit and share the video. I will send out all the speaker notes that I have access to, and if there are any further to come, I'll share those as well. And then I will also, if the speakers are happy, I'll pop their contact details in there. So if you would like to get in touch with them, have any further questions or any issues, obviously then you've got a way to do that. But as I say, the video will also be put on Legal News later today as well. So yeah, I'll let Christian close the session, but from my point of view, thank you very, very much for joining, and also for staying on mute as well. I really appreciate that.
Thank you very much, Emma, for hosting today, and thank you for everyone for attending. And if you do have any questions, as Emma said, please get in touch with us at Chambers, either individually or through the clerks, and we'll be more than happy to assist. Well, thank you very much, and stay well.
Thank you. I'll end the meeting for everybody. Take care.
Bye.
Thank you.